Cloud. Okay, so today we're going to be covering chapters 22 and 24. And again, today's actually going to be a very short lecture because we're only covering two chapters. And what I like to do is when I read the textbook and when I prepare my notes, I'm really getting to the nitty-gritty stuff, the stuff that I really want you to know that I think is important for you to know in real life, not just, you know, stuff that you'll never use. As always, if you have questions on any material, you can feel free to stop me or email me throughout. We're really getting down to the wire. It's weird, really weird to think that we're already, the last third of the semester, and that we only have really a few more classes, and then we're going to have our final exam, and then we'll be done. So it's been an interesting perspective from my end to do this whole online thing. But I hope you guys are learning something, anything, but I can't tell because nobody talks. Very few people talk, and I don't see anybody's faces except names. So I'm looking at a screen with a bunch of letters on it. But let's go with chapter 22. And let's see here. Chapter 22, where the first thing that we actually talk about is warranties. And with warranties, let me go back to my stuff here. Okay, you've all heard the term warranty, right? You've heard the term warranty when we talk about when you bought something, it comes with a warranty, or when you buy something and it has an extra warranty that you can purchase. What is a warranty? Give me the iPhone, absolutely. So furniture, televisions, dishwashers, any of that stuff, right? Tell me what a warranty is. If I did not know what a warranty is, tell me what it is.
Warranty is like if something happened to that product, they're gonna replace or like repair that product and give it back.
Right. And sometimes when you're buying a new product, it already comes with a warranty. Warranty covers the price of any damage on the product. Correct. But sometimes they ask you, hey, do you want to pay for this extra warranty? Do you want to pay a little extra money? And that way you're worrying, you don't have to worry at all about it. And so sometimes you buy the extra warranty and sometimes you use it, sometimes you don't. Warranties are meant to reimburse you. A company is saying that our product is going to work for a X period of time in this period of a particular way, and if it doesn't, we're going to reimburse you. And why do companies do that? They're trying to earn your trust because they want you to know that their product is a good product. That way you have faith when you're actually buying it. Does it apply when you're buying something secondhand? It could. It depends on the warranty, how it's drafted. If it's going from one person to the other, it could potentially be void. And one of the things I'll tell you, when we bought furniture, right? First time my husband and I bought furniture, we bought it with the warranty. Did we actually use it? No. But what it actually says is, so let's say I sell my furniture to somebody else, that warranty is voided. So even though we had purchased a 5-year warranty on our furniture, if we sold it to somebody else, a third party, 2 years down the line or 3 years down the line, that warranty would be void. So it was only particular to us. Now, there are some items where the warranty can carry over. Interestingly, and you just know this with life, when we had wood flooring installed, it had a 100-year warranty on it. And obviously, we're not going to live 100 years, so it extends. It's not just for us, but whoever else comes into play and lives and uses the wooden floor. If the wooden floor doesn't perform as it's supposed to, then that warranty is supposed to cover it. What does it even mean, really? Well, it's supposed to not have certain scratches except from, wear and tear. What you also look at in warranties is a lot of times if you're buying a product, it'll tell you with normal wear and tear, not for commercial use. If you're using something in a commercial fashion, like a blender, let's say, and it goes bad, well, that's in that situation, then the warranty is no longer good. I've tried to get certain products have like the warranty cover if something didn't work, and sometimes a company will honor and send me a brand new product, and sometimes they will not. They'll try to get out of it. So it's always a good idea to try, especially if it's an expensive item and you have that warranty on it, to try. I like to register all my products that I get to do the little warranty thing. That way I have information, proof of purchase, everything is right then and there. So always a little tidbit for you. Now, when we talk actually about warranties. So we spoken now about the generality of it, but now let's talk about the legality aspect of it. Now, in order for you to bring a warranty action, you have to show four things. This is something I want you to know. So this is a write it down moment. Okay. So to bring a warranty action, you need these four items. Number one, the buyer must prove a warranty existed. Number one, the buyer must prove that a warranty existed. Number two, the warranty must be breached. The warranty must be breached. Number three, breach of that warranty caused a loss suffered. Breach of that warranty caused the loss suffered. And number four, notice of the breach was given to the seller. Number four, notice of the breach was given to the seller. I'm going to say all four again. So to bring a warranty action, the buyer must prove that a warranty existed, the warranty has been breached, breach of the warranty caused a loss suffered, and notice of the breach was given to the seller. Again, I want you to think about this in a common sense way. If your iPhone broke, you have to show that a warranty existed, right? So when did you purchase the phone? And is it still in warranty? So you would have like the purchase date or the receipt or something to show, right? You have to show that Apple Care. You have to show that the warranty is in fact existence. If you're outside the warranty period, you're not going to be able to do anything. Number two, the warranty was breached. How do you show that? I expect that my phone is going to be working. I'm turning it on. It's not going on. It's doing something wacky. Okay. So I'm expecting that if I have a phone for 6 months, it's going to still be operational. It's not operating. There's something wrong, right? So the warranty, the company's representation that this product is supposed to do X, Y, and Z, it's not valid. It's not happening. Number three, breach of that warranty caused the loss suffered. Me not being able to use my phone has caused me great anguish. I am suffering here because I can't use my phone. Number four, I've given notice of this breach to the company. If all three are done, but I never actually like tell Apple that there's something wrong with my phone, then what am I going to do here, right? You have to have all four in order to bring a warranty action, okay? Any questions or pretty common sense? Okay. Questions? No? Okay, moving along. This is now a listening thing. Under the UCC, which we spoke about last time, when a seller sells an item, it's implicit. It's in there. It's kind of like known that the warranty, that this item works in the way that it's supposed to work, and that it's free from any and all defects. So when somebody sells something, they're supposed to be selling you something good, something that you're going to be able to use, and that they in fact had the ownership of that item, right? You cannot sell something you don't own to somebody else. It's not yours. We kind of talked about that whole concept in the beginning of the semester. There's different types of warranties. Okay, there's express warranties and implied warranties, and there's one more that you have not heard of. But you've heard before the term express, right, and implied. We talked about express contracts, implied contracts, and when we talk about an express warranty, it is a contract. It is written. There is no doubt that there's a warranty that exists. And an implied contract may not be written. It's usually not written, but the circumstances dictate a warranty of some sort. How do you know that a contract was implied? It depends on the situation. It depends on the circumstances surrounding it, but you would have reason to believe that a warranty exists from the circumstances. Generally speaking, I'm obviously a big proponent of a, written warranties. If you buy a shirt, let's say, right, you're buying it from Macy's. um, you are buying it, you're expecting that the shirt material is not going to fall apart after you wear it once. So it's not written anywhere that the shirt is not going to fall apart. It's implied that this shirt should remain intact and cover your body for as long as you wear it, or for, at least a certain period of time. Now, there's also this other type of warranty. It's called a warranty that's fit for a particular purpose. And this is an interesting one because it covers you and it gives you like an implied warranty when you're trying to purchase something and you're telling the seller that you want it for a particular purpose. And so when you buy something and you've indicated to the seller that it's for a particular purpose, it's supposed to uphold that purpose. So if I go to Home Depot and I tell them I'm looking for good quality kitchen cabinets. I want a kitchen cabinet where the those knob thingies, the knobs don't fall off. I want it to be sturdy and not like all jiggly or whatever. And I tell that to the Home Depot person and I buy something and then I take it home and a year, 2 years down the line, the knobby thingies, it's not that they're loose that I just have to screw it. They're no longer attached to the cabinet or whatever it is. I can go back to Home Depot and say, hey, I purchased this with a specific purpose of I didn't want these knobby thingies to fall off. It could a better example maybe like where the wood is not falling off or where the glue is not coming apart, something like that. The whole idea behind this legal concept is when you are telling the seller that you want an item for a particular purpose. So it's got to be, you're relying on the seller's judgment for whatever product that they're trying to sell you. You go to Best Buy and you tell them that you want a TV that has all this fancy technology and they sell you one that doesn't have all the fancy technology. Well, you purchased it based on a seller's representation about this fancy technology. So you'd be able to go back and return it because you didn't get the fancy technology. I know there's words that they use and letters HCGIM, whatever, all that stuff, but you get the idea. Does anybody have any questions about fitness for a particular purpose or express or implied warranties? Okay, I'm going to move along. The next thing in this chapter is privity of contract, and this is a listening one. So this may ring a bell from when we spoke about contracts, right? A and B enter into a contract with one another, and A tells B they're guaranteeing a particular item, and then B sells this particular item to C. C can't go after A, okay? Because the contractual obligation was not between C and A, okay? They would have to enter, C would have to go after B, and then B would have to go after A because there was no direct correlation between A and C. So privity of contract is a concept that says you can only go after the person who you entered into a contract with, not necessarily a third party. That applies for warranties because we know that from contracts, sometimes you can go after a third party by bringing them in, but if you didn't enter into a contract with that particular person, you would not be able to go after somebody else. You just go after that person that you entered into a contract with. Now we're going to talk a little bit about like defective products. And this is something I want you to write down exactly as I say it. And this is about strict liability. And with strict liability, when it comes to products, I'll put this down in the chat. A seller is liable for selling a product if it's in a defective condition and unreasonably dangerous. It focuses on the product, not the seller. So your focus is the sentence you're going to be writing down, and I'm going to put this down in the chat, is strict liability focuses on the product, not the conduct of the manufacturer. Let me copy this here for you. Copy. Okay, strict liability focuses on the product, not the conduct of the manufacturer. Okay, so strict liability focuses on the product, not the conduct. The inherent problem is with the product itself. And how can that be? Well, we take a look at the actual product itself. Okay, um, let me see here. So sometimes it's a defect in the manufacturing, sometimes it could be a defect in the design. So when we talk about a manufacturing defect, it's a very different idea than a design defect. So in a manufacturing defect, it's the manufacturer, the entity that's putting together the product, uses something that they weren't supposed to use. And so when they're putting the product together, it's not working. So let's take an example of a chair. A chair with four legs, a seating thing, and a back. And let's say in order for the legs to adhere to the seat, they need to use 12-inch long nails. And so when they were, this company now, this manufacturer, when they were putting together the chair itself, instead of using 12-inch nails, they used 8-inch nails. And so people were sitting down, a leg was breaking, and they were falling. So they were getting injured. So the problem is not with the design itself, it's with how the chair was manufactured, how the chair was put together. Different than when we talk about a design defect and the warranty that's attached to that. Why? Because a design defect says that the actual design of this item was inherently poor. It was poor engineering, perhaps poor choice of material. It's it was done in such a way that was going to be dangerous. So instead of having, let's say, a chair with four legs, some, kooky design person wanted to have a chair with three legs and a triangular seat and a pointy legs, right? That might be aesthetically pleasing if you find that stuff pleasing, but from a design perspective and an application perspective, it's not safe. Somebody's going to sit down, the weight might not be distributed evenly, and so the chair will break. So it's the actual design of the product that then causes it to fail. An example I'm going to give is actually a real life example, and that's with the Pinto car. I believe Ford made a car called the Pinto, and they had placed, if I recall the facts of this correctly, the gas tank was placed uh, too close to the rear axle of the car. And so sometimes the car would blow up because the sparks would fly and it was too close. Like, so when the car would let go, um, the fastness of the thing in the back would hit the gas tank, and bam, you had Pinto cars exploding. Not good. There's also and I don't know if this was a design defect, it has to be. If you remember a few years ago, I don't remember how many years, my brain doesn't operate that well anymore. Remember when the Samsung phones were blowing up, they were catching fire? So that was a design defect. They were perhaps getting too hot and they weren't cooling down properly. I think it was maybe like when it was being charged. That's a design defect, maybe not a manufacturing defect. Let me see what else I want to tell you here. Um, okay. The other thing I want to tell you about, it's a concept called failure to warn. And I love this concept. I want you to know it. Failure to warn is when a product is defective or can be defective and notice is not given to the consumer. So proper notice is not given to the consumer that it could be used in an incorrect way or it could be defective. And the example I always use, and I think it still holds true today, is with Tide. Anybody here use Tide pods to do your laundry? No? Okay. Well, somebody, Tide pods, they
Don't
actually,
want our teenagers eating them in some crazy challenge, you know?
you're right. I know. I'm amazed when I hear about the crazy challenges people are coming up with. But yes, there were a bunch of teenagers. crazy young people that were eating them. It was the Tide Pod challenge, but there was actually a problem with the Tide Pod, not so much for the crazy teenagers, but for children. The Tide Pods, what do they look like? If you are a 4-year-old or a 5-year-old and you saw them, what could you possibly think that they were? Candy, that's right. So children would see these little balls that were like a bright orange and blue and white. And what were the kids doing? They were eating them. And so there was a lot of lawsuits then that were starting to occur. People were suing Tide. And so what Tide did was they didn't withdraw or pull the product. They went on an active campaign to put people on notice, to educate consumers. Your kids might eat these, so don't leave them out for your children. They would say that, don't, if you look up, just if you Google, like after we finish class, Google Tide Pod commercials, and you'll see a transformation in the Tide commercials, because, the most recent ones, they have the container. They tell people, like the parents, oh no, don't leave it out on the floor, put it up on top, right? So the kids can't get it, so the kids can't eat it. And they're ultimately putting the parents on notice. Hey, parents, it's your responsibility to make sure your kids are not eating these Tide Pods. Unless they're teenagers, of course, then it's something else. But you don't want to be able to have kids mix this thing up and think that this is actually candy. So they went on this campaign to educate parents. What else? What other company? You're not going to know. I'm going to tell you because it's just so much fun for me to talk about this stuff. IKEA, right? IKEA products. IKEA also went on this like active campaign with commercials and stuff. What was happening with IKEA products? No? Okay. Kids were climbing up the shelves. And so the kid, that's right, the product would then fall and crush children. So they went on an active campaign again to notify parents that whenever you're building these shelves, whether they're bookshelves or whether they're like bedroom sets or whatever, you have to make sure it is fixed into the wall. That way, if a kid climbs, it doesn't fall and doesn't crush them. And if you don't have children, you may think, why would kids do that? Obviously, they wouldn't. Let me tell you, they would. My 3-year-old, my rambunctious 3-year-old, he climbs on all types of furniture. As a matter of fact, sometimes he thinks he can fly. And so he will go on the bench that we have on our dining room table and he will launch himself to try to land on the couch. Sometimes he gets it, sometimes he doesn't. But what we did was we tried to safeguard the house as much as possible. But these companies, they put you on notice so you can't sue them. Okay, so that's failure to warn. The one case that I do want you to know is, it's a great case. I love this case, so you must know it. Kessler versus Bayer Corporation. Who would like to tell us about Kessler versus Bayer Corporation? Great case, great case. Who wants to tell us about it? You guys don't get homework. Don't forget that. This is your responsibility, is simply to read in preparation for class. Kessler versus Bayer Corporation.
I've read it though.
Thank you, Martin. You always come through. What
No,
can you
I'm
tell
just
us about
waiting for
Martin?
somebody else though, because I'm talking too much. It's not
No,
on the
no,
radio.
Martin, you're doing great. I appreciate it. And let me tell you, if you did not volunteer, then I would just test on the case and I wasn't going to say a word. So you're actually saving your classmates. So thank you. What can you tell us about Kessler versus Bayer Corporation?
So this gentleman used moisturized spray or something like that
Nasal
for
spray.
yeah. For about like 3 years or something like that, for
Correct.
a little while, and in the end he got some. He basically had to replace his nasal tissues or something like. He has to go to a surgery, basically,
Correct.
couple of surgeries actually, not a
Yep.
surgery. And so he took the manufacturer, which is Bayer, a huge
Mhm.
medical company in Europe and everywhere around the world.
Mm-hmm.
Anyway, so and he argued that they didn't warn their customers that this product is dangerous and it's gonna cause them, trouble. But buyer respond that there is a small part of the label, I guess, text that
Mm-hmm.
is warning that if you use the product more than 3 days straight, uh, more than 3 days in a row, you might get some warning or whatever. Some I don't know what to say that.
They actually warned
You
and
might,
said, do not use more than
yeah,
3 days.
more than 3 days. And if you feel, if you feel something is going on with your body, you just contact a doctor or a specialist so they can help you out with that.
Right.
So the gentleman didn't do that, and he ended up in the hospital doing the surgeries, and he basically the court, I think the court, they they said that buyer were able and they produced the product with a warning label, right?
Yep. Yep. Exactly.
So it's not their fault, yeah, that he's been using it for that long, such a long
Right.
time, and he got, yeah.
Yeah, no, absolutely right. They he used this product for 3 years. Meanwhile, the label said, do not use more than 3 days. Seek the help of a doctor if your condition doesn't get better, and he did not do that. So he lost, he appealed, and he also lost the appeal. Why? The label said, don't use more than 3 days, and he used it for 3 years. Always read labels on items. If you use Tylenol, take a look at your Tylenol bottle. Look at the warning the Tylenol bottle gives you. Okay. There's a warning on there about how many days you're supposed to use it and what you're not supposed to mix it with. Okay. Because it could cause certain damage to your body. Do people read things? They don't. You should read these things. That way you don't get sick or make your condition worse. Thank you, Martin. Very good. Okay, there are, so that's the argument of like failure to warn. There's also like another concept when it comes to warranties where it's something like an unreasonably dangerous condition. And you can sue for that within the context of warranties if an item was dangerous beyond that which was contemplated by an ordinary consumer, right? So it's is something unreasonably dangerous? So that's the question. Well, if you drink, let's say, whiskey or alcohol and you drink it in excess, it's going to be dangerous, right? But it's not the product itself that is dangerous, it's how much you've consumed of it. If the whiskey was laced with some kind of poison, okay, then it doesn't matter how much you drink from it. It was inherently dangerous or unreasonably dangerous because there was something wrong with it. Like if you sometimes the recall on food, if you buy lettuce and they recall it or chicken because there was something in there. It's not the product itself. There was something that was tied into it then that made it more dangerous. Butter, right? Butter could be considered dangerous. It causes heart, cholesterol, all that stuff. So if you eat a ton of butter, is that unreasonably dangerous? No. But again, if you eat a butter that had some kind of if rat poisoning mixed in with it, that's going to be unreasonably dangerous because you're not expecting to die of poison from eating butter. Maybe a heart attack, maybe high cholesterol, but not because of the poison aspect. Okay. So now let's say you sued, and what is going to be the recovery? So you're suing based on something that was unreasonably dangerous or that there was a failure to warn of the danger of that item. Well, when we talk about negligence, it's a does butter have a warning? No, butter does not have a warning. Does not have a warning. Um, no, it does not. Just like eating bread, right? Bread does not have a warning. Food generally doesn't have warnings, but if you eat too much food, it's not good for you. But that's, I guess, just general info. Okay, when we talk about contributory negligence, it's not a defense in a strict liability because the manufacturer is not going to be able to point a person and say, this person did something wrong. Because don't forget, when we talk about strict liability when it comes to a product, we're talking, the focus is on the product itself, not the conduct of anybody around it. And when we talk about comparative negligence, this is more of listening stuff, guys. Comparative negligence is depending on the state that you sue in. If you're using a product incorrectly and there was a level of wrong on your part, then again, like we talked about in the beginning of the semester, maybe the court will award you or a jury will award you $100,000. But if you are 40% at fault, you're only going to be able to recover, let's say, 60,000. That's really, somebody just wrote that cookie dough does have a warning, like do not eat raw because probably it has eggs in it or maybe salmonella. Yeah. So speaking of cookie dough, we got this cookie dough that looks like ghosts for Halloween for the kids. And on it, it says specifically you can't eat it raw. But most of the time, cookie dough does say you cannot eat it raw. Why? They're putting you, the consumer, on notice. They're giving you that notice. That way you can't come back and sue them saying that you did not know. So good. That's good. Okay. Next concept should sound familiar to you. It's called the voluntary assumption of risk. If you engage in an activity that is dangerous, obviously you're assuming that risk, so you're not going to be able to sue. The same concept comes into with product. If you are, yes, skydiving, exactly. If you now use a car or use a saw or something dangerous and you're not taking the proper safety precautions, you may be assuming the risk that something bad could happen. And so that could be a defense to strict liability. Why? Because you assumed this risk. You didn't take the proper safety precautions. So you assumed it. There's not going to be any liability on the seller's part because you assumed the risk in this inherently dangerous product or inherently dangerous activity like skydiving. I am a wuss, right? I will not engage in any of these things because I'm always thinking about, if I die, if I get injured, what's the liability? That's what I think about. Are we going to be able to sue or not sue? I think I had mentioned to you before, like my husband is an OBGYN. And so when I was having my first kid, Christopher, my husband was working. He was a resident at that time. And I said, I didn't want you in the delivery. Like you can be there, but I don't want you to have anything to do with it. Why? In case I have to sue. In case there's a problem that happens and I have to sue. So that's how my brain operates. It's always like, is there liability? And my boss's husband died jet ski in Bahamas. He was a doctor. I wonder if that fact pattern. Yeah. My dad's friend from work, it wasn't jet skiing, he was skiing. And he went into a rock or a mountain and he died that way. And so when you're engaging in what could potentially be dangerous activity, you're kind of giving away any sort of recourse that your family could have because you're engaging in a risky behavior or a risky item. So I don't like to do any of that stuff. Mind you, I could just walk outside and get hit by a car, right? But I don't like to take on that unnecessary risk. I would like to say that I was more, I could lie to you and say that I was more of an adventurous person when I was younger, but I wasn't. I was never really wild and dangerous. But yeah, that's, to each his own. Okay, when you misuse or abuse a product, okay, that could also alleviate the seller, the manufacturer, from any liability because you're using a product incorrectly. So if you are using let's say you needed to change a light bulb, and you're looking around and you don't have a ladder, and so you only have a rocking chair. So you decide to use a rocking chair to stand up on it to change the light bulb. The rocking chair may not be stable. It's not going to be steady. You fall. Are you going to be able to sue the manufacturer of the rocking chair because you fell off of it? Well, you can always sue. Whether or not you're going to be successful is a different idea, right? Because you're not supposed to use a rocking chair to stand up on and change light bulbs. A rocking chair is meant to sit on and rock back and forth, right? If you are, what else could you be doing? If you're using a blender and not, let me give you a perfect example. A friend from work, the mandolin that you use to slice food, right? It comes with a safety handle. She used it, but she didn't use the safety handle. She cut like a piece of her finger off. She had to go to the hospital. She had to have skin grafting. Can she sue the mandolin company? No. Again, she can sue. She's not going to win. Why? They gave you a safety cover. You have to use it. I have a mandolin. I always use a safety cover. That's how the brain of an attorney works, right? Because if I'm using it, I don't want to get hurt. And if I do get hurt, I want to be able to say that I used it, the product as intended, and now I can sue and try to get some kind of recovery. Okay. Also, the last thing for this chapter is the idea of subsequent alteration. If you take a product and it tells you to use it A, B, C, and D, and you decide in your infinite wisdom to remove a safety feature so it can make it go faster, and then something bad happens, you're not going to be able to win, or you're not going to be able to succeed on the merits of your claim. Why? Because you altered a product. And I remember a case when I was an intern in the magistrate court in New Jersey, and there is a man, he was using, I think he ended up suing Black and Decker. He was using a circular saw, and he removed the safety feature because he wanted to go faster with he was sawing. The blade came off, and like, I don't remember if it cut off his like artery or something. He died, right? And so his family was trying to sue, and he had removed the safety feature. And I remember as an intern, I did speak to the attorney who handled the Black and Decker. I'd finished my internship prior to knowing the outcome of the case. But in a case like that, somebody certainly died, but he took an active approach by altering the product. Can his family sue and recover? I don't know. They shouldn't be able to, unless they can make an argument. Excuse me. Unless they can make an argument saying that, the box or the product did not warn that you're not supposed to move this, or that removing it can cause death or something of that sort, right? If you don't know the inherent danger of it, and then you move this product along, or you alter it, then it could be a problem. Okay, so that concludes everything I want you to know for chapter 22. I'm going to give you the secret phrase for the evening. Secret phrase for the evening. This one is, hold on, I wrote it down. Okay, Christopher loves building Lego ships. The secret phrase for tonight for attendance purposes is Christopher loves building Lego ships. Christopher loves building Lego ships. This is Christopher. That's the Lego ship. That's his latest creation. Christopher loves, go away now. Go. Christopher loves building Lego ships. Okay, we're going to move on. And we are going to go on to chapter 24. That's what happens, right? So you get a little bit of everything at home. Okay, chapter 24. Let me just look at our syllabus. Okay, chapter 24, it's very short because it's I don't think it's as useful now as it was 10 years ago, let's say. So chapter 24 talks about the negotiability of instruments, in particular, what you can use instead of money to make transactions go. And so this actually had focused on checks. And at that time, right, this is a write it down moment, the check was the most widely used form of a negotiable instrument. So what is the most common form of a negotiable instrument? What is the most common form? This is a write it down, write it down. What is the most common form of a negotiable instrument? It was the check. Okay. And so negotiable instruments is a concept that allows a written instrument to be used in substitution of money. Now, if we were to talk about today, what are we using instead of cash today? What do you guys use? You go out to dinner and
Venmo, Cash App,
yep,
PayPal,
yep,
Zelle.
exactly.
There's a
All
billion
that
of them.
stuff, exactly, right? Are you writing out checks to your friends? How many of you, honest, raise your fake, virtual hand here. How many of you have written a check in the past month? Raise hands. Anyone? Do you even know what a check is?
Actually, me.
Okay, tell
Yeah,
me.
but it's because I do the checks for my mom. She pays the house and she don't know English, so I have to write them. But that's the
Okay.
only reason that I know how to write a check.
See? Exactly. So like checks are not as common. I write a check once a month where we live, like maintenance for we live in a co-op, right? So that's because they don't accept any type of, direct deposit or electronic payment. It's the only reason I have to write a check. Otherwise, once I discovered Venmo, it is actually the easiest thing. So you use okay business checks for your family's business. So I would imagine that I don't want to say old school, but like businesses perhaps would still have it. But a lot of times, what are people using? They're using electronic payments of money going back and forth. So that's why I'm not going to spend that much time on this. I'm going to just go over a couple of things that I want you to know. So you may have always at your service. What's easier, Danielle Santarpia? What are you saying here? Hold on. It's so much easier. What's so much easier? Like Venmo? Okay. Yeah. It's I think it's also what you are used to using. Like my mom my mom, forget Venmo, forget Zelle, forget checks. She doesn't do any of that stuff. My mom's gonna use a credit card. Like that's what she's grown up with. That's what she knows. That's what she's gonna use. It depends on what we're used to. And so when you have somebody that's perhaps a little bit older that may not be used to certain ways, it's not gonna change. But for purposes of this chapter and the things I want you to know, also, a promissory note. What's a promissory note? It's basically a contract, an agreement where a person states that they promise to pay you. It's like an IOU for kids. Remember when you were a child and you wrote, maybe when you were children you didn't have IOUs. An IOU, like I would, it's literally just you write the letters IOU to a friend. It's like I'm gonna give you this, I owe you a milkshake or I owe you a cookie from tomorrow because we exchanged lunch. But kids aren't allowed to exchange lunch anymore. They have to like eat their own lunch. They can't switch that up. So that's what a promissory note is. A promise of one person saying they're going to pay somebody else. Now, when we talk about negotiable instruments, I'm going to actually just put this in the chat. And these are the things that must be in a negotiable instrument in order for it to be valid. It's got to be in writing. It's got to be signed as to contain a promise. Jinx, you owe me a soda. Unconditional for a fixed amount for money contained. Oh, yes. Jinx, you owe me a soda. Gotcha. Yes. So then it's like an IOU of sorts. And the promissory note is the adult way of having that. And when we talk about a check, in order for a check to be valid, it has to have these 9 items that are now in your chat. Okay. So it's got to be in writing. It's got to be dated. It has to say who it's going for, things of that sort. That's so it can be valid. Does that apply to Venmo? Let's try to compare that. When you're doing a Venmo transaction to somebody else, is it in writing? Yes. Is it signed? Are you signing anything? You're just pressing OK. Like you giving it your confirmation could be construed as a signature. It's the authority that you're giving to that transaction being going over. Does it contain a promise or an order to pay? I guess maybe that's the agreement that you have with the financial institution when you first signed up with it. Is it unconditional? Yeah, once you send that money, that's it. You're not going to be able to get it back. Is it for a fixed amount? Yes. Is it for money? Yes. contain no other undertaking or instruction. Well, I don't know. Does that happen with Venmo? Most of the time, yeah, but can you deviate from that? Can you say I'm only going to give you this check, or I'm sorry, I'm only going to pay you this much money if you do X, Y, and Z, where it's conditioned upon something else? I suppose you could. Payable on demand or definite time. When you're doing a electronic transfer like that, it's instantaneous. It's not like you can post date a check. I don't know if you guys even know what that is. Back in the day when people, or if you're familiar with the concept now, if you didn't have money in your account today, let's say you're going to get paid next week, so you would write a check with a date of next week, and you would tell somebody, don't cash it in yet because I don't have any money in there. So that's kind of like the payable on demand or definite time. It's like that instruments. But when you're doing Venmo or any of the electronic transfers, once you press go, that's it. It's going. It's done. And payable to an order, payable to somebody else. So those are the requirements of a negotiable instrument. Let me just see here. Okay, this is write it down. So in order for you, money, like the way that we use money, it's authorized, like, take it back. Let me explain it first. Why do we not use chickens, or books, or phones, or gold to barter, to exchange, right? Those items are not sanctioned by the government. So you can't use those items. It's not going to be recognized by the government. It's not a form of money. So money, it's a medium of exchange that is authorized by a sovereign government. That's the currency that we're using. So bartering is not sanctioned by the government.
So what about like Bitcoin?
So
like
that's interesting.
from
yeah. Go ahead.
I was going to say, because from economics, I remember the definition of money didn't necessarily have to do with sovereign banking, but it was like a store of value, a medium of exchange, an account of record, and it's been a while. I don't remember.
No, that's okay.
There was a fourth thing, but none of them actually had to do with like government backing.
And so
it was,
with money, when we talk about the legality of it, not the economics idea behind it, money, it's a medium of exchange that is authorized by a sovereign government. That's why if I'm going to go to a store and purchase something, I'm going to give them money. They're not going to take something else. And if they do take something else, would I be able to sue them? Perhaps I could. Bitcoin, I don't know enough about Bitcoin. I tried to really understand it, and it feels like it's a whole world I don't understand, with all this electronic technological stuff. So I'm not going to comment because I don't like to give false information. But I know that there's people that have made a ton of money on it, and people that have lost a ton of money on it. So that's the extent of my knowledge. But for purposes of our business law and money within the context of this chapter, it's got to be something that's authorized by a sovereign government. And that is going to be actually how we conclude chapter 24. There's nothing else that I would like you to know for this. So does anybody have any questions on anything we covered so far tonight? Anyone? Okay. If there are no questions, we can conclude for the evening. Everyone have a great night, and I will see you next week. Good night.
thank you, Professor. Have a
You're
good night.
welcome. Good night.
Professor,
Good night.
Bye-bye.